I really just want somebody who's going to aggressively fight for me in court. Is that too much to ask?
Filing an eviction should not be complicated. There's got to be an easier way.
Nothing frustrates me more than having to wait for my attorney to call me back. I need them now.
What I really need from my law firm is someone who can provide my staff training so we actually can stay out of trouble.
When you have property management problems, we have your solutions. This is the Zona Law Group podcast with the experienced attorneys from Zona Law.
Well, hello and welcome to another episode of the Zona Law Group podcast. I'm David Pickron, your host, and today I'm excited to have with me one of the many great attorneys over at Zona Law, Chris Welch. Chris, how are you doing today?
I'm doing good.
Awesome. Chris, we're excited to have you. I know that you've seen a lot, you've been to court a lot, you've met a lot of people, and I always say, I wish I could take all of our attorneys' heads and just dump them on the table because there's just so much valuable knowledge here. And I love this medium of a podcast because it really allows us to dig into your head and kind of pull out all those years of experience and knowledge that you have. But before we get going on our topic today, I want to ask you a question, put you on the spot a little bit, is how did you become an attorney?
Well, it's kind of interesting. I always wanted to become a dentist. My whole family, they're all doctors and dentists, and it just seemed like a natural fit. My dad only worked 4 days a week. I thought that sounded great. But when I was in college, I couldn't handle the science or the math. I was not getting good enough grades, and I knew I wouldn't get into dental school that way.
It would be the blood that took me out. Are you okay with the blood? Or?
Yeah, the blood never really bothered me.
Okay.
But the grades did. So I talked to a family friend who's a judge in Nevada where I was going to undergrad, and he said, well, what are you good at? And I said, history and English. And he said, well, then you should go to law school. You can do anything with a law degree.
Right.
And he encouraged me to do that, and I switched majors and ended up going to law school.
Now, was your family like, hey, we need another doctor, or were they like, we have too many doctors, so that's great?
Yeah, no, they were fine with expanding out a little. I have my brother and a bunch of my cousins are all doctors now, and I'm the only lawyer in the family. So,
well, your teeth look white and you look healthy, so it looks like you've got good support behind you. Well, today we're going to talk about probably what we spend 90% of our time with, something that's pretty straightforward, and yet we can get into a lot of trouble, and that is the eviction process. And what I want to say about the eviction process is we never want to come off at Zona Law as we're going to kick out a guy. I mean, we never really want somebody to lose the roof over their head. It's kind of a sad experience that we're in the middle of. But I imagine we have to live in the world of we have an obligation to our clients.
Correct.
Right?
Yeah. I mean, sometimes you're in court and it's a sad day. Someone's there. I've had guys struggling with cancer. He's got bills. He can't pay the rent, but he understands I have to pay the rent. My landlord deserves to be paid. There's a written contract there. Sometimes I think the judges do a good job of explaining it. Sometimes they'll say, just because you can't pay the rent doesn't mean you're a bad person.
Right.
But as you stated, our biggest priority and we have to support the landlords and our clients and allow them to get the money that they need for their business to run.
Absolutely. Your obligation is to your client, no doubt. Well, let's talk about the very beginning of the process, and let's break it down to I'm a landlord, and the first comes, and rent doesn't come on the first, and I'm starting to get a little nervous, and I wait till the second, and the second doesn't come, and I'm starting to think, okay, are they on vacation? I'm starting to talk myself into why isn't the rent coming, and so rent doesn't come day 2, 3, 4. What do you recommend?
Well, obviously, we want to have a strong lease agreement in place that explains, okay, rent is due on the first,
okay.
And then late fees will kick in. Whatever the lease says, I think it's best to follow that. If it's due on the first, obviously, we expect that rent payment to be there. But if there's a grace period built in till the 4th, let's say, then I think on the 4th, if the rent's not there, you definitely want to get a notice for non-payment of rent. That's a 5-day notice that gives the tenant the opportunity to pay what's owed, the rent and whatever late fees have accrued, in order to cure the breach and reinstate the lease. And that means they get to, if they pay, they get to stay. But if they don't, then the eviction process would commence once that notice has expired.
And hopefully in your lease you have a $25 notice fee, because the tenant's going to have to cover these expenses, the extra work that you're doing to try to get your rent from them. So hopefully you'll have a $25, $35, fee due on that day to pay for the notice to be, typed up and delivered. And then there'll be usually a daily late fee after that.
Correct. A lot of the time there's an initial hit of like $50 or $75 for the late, but then a daily fee built in, because there does need to be some kind of incentive for tenants to pay. If it's late and there's no built-in late fee that's building, they're just going to wait until the 10th and pay, whenever's convenient for them, and the landlord might need that money obviously on the 1st.
So now when this 5-day notice needs to be delivered, and really what the 5-day notice is saying, and correct me if I'm wrong, is you have 5 days to pay or I'm going to file in court on you, correct? That's the 5 days.
That's right.
Okay, it's not that you're 5 days late. It's that in 5 days moving forward, if you haven't cured this, we're filing an eviction action against you.
Correct. And I think it's really helpful to be clear in that notice. It says your rent was due on the 1st, and now you owe this plus whatever the late fees are. If you don't pay in 5 days, then the eviction will start.
I do love a 5-day notice that does lay it out. If you pay on the 5th, it's this much. On the 6th, it's this much. If it's on the 7th, and then that way you're not getting that check that's short, a day or two of late fees. So I think properly doing that 5-day is very important.
Yeah, and like I said sometimes the judges do a really good job, and sometimes they get a little bit too tenant friendly, in our opinion, where they nitpick at a 5-day notice. And you never want to get all the way to court and then have the judge say he's unhappy with your 5-day notice. So we do definitely want to lay that out correctly so that there's no questions.
Okay, perfect. So I see a lot of mistakes made when our landlords deliver this 5-day notice. So there's 2 options. What are our 2 options?
So the 5-day notice, the best option is always to hand deliver it. If you're able to give the notice to either the resident or an adult, someone of suitable age and discretion is the term, you give them that notice, the clock starts to run on that notice right away. Okay. There's that 5-day period. The second option is to certify mail the notice. Okay. If you go and you try to hand deliver it, they're not there, you can post the notice on the door and then send it by certified mail. The reason that's not quite as good of an option is because they get an additional 5 days for mailing. Okay. So it actually kind of turns into a 10-day notice at that point.
And it's interesting, the law says hand delivered, and there's a little gray area. They're like, well, Judge, I hand delivered it to the door. That is not what the intent of that law is saying. Hand delivered is personal service, giving it to somebody in person.
Correct. Unless you can say, I put it on the door and I watched the tenant take it off the door, which is a very rare thing. You definitely want to have hand delivery. Right. Otherwise, it could be deemed an insufficient notice. Well,
and I've seen it many times in my life as a process server. I'll go post the 5-day notice on the door, I'll slide it in the door jamb. The people just are afraid. They don't know who I am. They don't want to open up the door, but they'll slide it in, and I'll try to have a conversation with them through the door. And I'll consider that personal serve or hand delivered because there was a live human being. Though I didn't see them, I had a conversation with them. And the reason they didn't open the door is they were just scared of it's 7, 8 o'clock at night. Maybe it's dark out. And I'm also not there to intimidate, the residents or scare them either. So I'm not saying that that's perfect. I would rather have someone open up the door, see their face, have a conversation with them. But it certainly is notice.
Yes, I agree. And I think landlords need to know, the reason they haven't paid is usually because they don't have the money. They're embarrassed. They're worried what the landlord's going to do. So they're trying to avoid service sometimes. So if you can accomplish it, like you said, that's great. Right. But if not, don't waste any more time. Get that certified mail and get the clock going.
When in doubt, certify mail it. I will tell you, most people do not accept their certified mail. So if you're a landlord and all you're doing is certified mail, most of your residents will not even know that the clock is ticking on them because most of them don't sign those green cards. Our statistics show 75% of the people never sign those. And so it's always good to post. Even if you're not going to get hand-delivered, you could still post it. At least gets the attention of the resident to say, okay, they're kind of reminding me I better get my money in. And that's eventually all we want. We just want them to pay rent. Right?
Correct. And if they can pay with just the notice, they're not seeing additional costs and fees yet. Right. So if they don't even know they have a notice until they get the court paperwork, by then the cost has gone up and they might be so far behind they're not going to be able to pay.
You make a great point there, because the more days go by, the digger the hole, the deeper the hole they're digging goes, and the harder and harder it is to get out of it. So, okay, so some new rules came about at the beginning of this year about what do landlords need to send their attorneys as they file for their non-payment evictions, and what are some of those things now that they've added?
Yeah, so we used to just file a few different documents. It was pretty easy, but now they've added changes, as you said at the beginning of this rule, that the lease agreement has to be included, and also at least 6 months of the ledger. And that increases the paperwork and makes it a little bit more difficult. But just this last week, I've seen numerous cases dismissed because the landlord failed to provide that documentation. I even had one landlord in court talking about, well, I gave it to the process server. He said he served it, but it never got to the court. So those cases were dismissed. They're going to have to start all over, pay additional fees just to get back in court for a non-payment. So we want to make sure that we have every document that we need, the lease, the 5-day notice and how it was served, and then that time period of the ledger that we need, the 6 months.
And the notice of rights to tenants that came years ago, right?
That's correct. That's a remaining holdover from the old ones. Yeah.
So our evictions used to be this big, and as we went out as servers, we could put them in the door jams. They were still thin enough, and now we're coming out with some of our clients have a 30, 40, 50-page lease, and we're having a hard time securing those documents when we post. And
yeah, we used to be able to use a paper clip, and now we're using binder clips or folders or whatever.
It's just made a little bit more difficult on us. And what's interesting about that is, as we try to file those leases into the court's like, we don't want them. We don't want you to file them. We're like, we want you to take them. And they're like, no, we're not taking them. So interesting that the court doesn't want to thicken their files, but they certainly want us to do a lot more work. Okay, perfect. So once we go through that, we file our eviction, we get it served. There's going to be a court date. About how far out is that court date?
So it depends on which court you're going to. Most of the courts meet at least 2 times a week for these eviction actions, and they have that set schedule. So if you get the cases in early enough, you'll get a court date early in the following week normally.
Okay.
If you, again, based on which court you're in, even if you get the cases in, you could be a week and a half out. But normally it's 5 to 7 days. Yeah.
Okay. So when you think about court cases in all different parts of law, this one really goes quick. And why do you think that is? I mean, I don't think we're trying to throw everybody out on the street. I don't think that's why it's quick. But why do you think that it's a fairly quick process?
So, as you stated, other court cases, I mean, obviously we've all seen them. They can drag out for years. Right. But here, it's what's deemed a summary proceeding, and the real reason why it goes so fast is because the only finding, really, that the court is making is who is entitled to possession. The tenant's entitled to possession if they're keeping up with the payments and following the lease, but the landlord's entitled to possession if they're not. And they're losing money, the landlord is, if they're not getting their rent. So the judge is able to come in, make a determination on that fact, who gets possession, and it has to be timely. And that's why it's allowed to go so much quicker.
And as a landlord, you have a mortgage due on the 1st. And then on the 1st, this thing drags out too long. This is really going to be detrimental to landlords out there. And so we're thankful for the courts that they recognize that we do need to protect our investments on our side. And I think probably within 21 to 30 days, you can have a complete eviction done here in the state of Arizona.
Yeah, normally. I mean, there's a few things that could delay it, but yeah, that's a pretty good number there.
So let's talk about a little things that can delay it. So I hand somebody a 5-day notice and they say, oh, I dropped the check through the night drop on the 1st, but you've never seen it as the landlord or as the housing provider.
Yeah, so tenants will come in all the time and say, look, here's my money order receipt. And it's like, well, great, that proves that you have a money order, but it doesn't prove that the landlord ever got it. So it's on the tenant to be able to prove that, but that does raise a question in the judge's eye. Well, wait a second, they might have paid. We need to get the landlord in here to testify as to what happened with the money. So anytime that there's a partial payment that's accepted or even argued, that can trigger a need for a trial or even get the case thrown out because the landlord's not supposed to take a partial payment.
Okay, which is great. I really wanted to cover that.
Mm-hmm.
I come in, I say, hey, listen, housing provider, I can give you $200 tomorrow. I can give you $300 in 2 days. I get paid on Friday. Should you put together a payment schedule like that?
Yes, you can definitely do that because a lot of the time some money is better than no money.
Okay.
But if you've already started the 5-day notice, you might be slowing things down for yourself.
Okay.
But if the tenant comes in and does that, like your scenario there is a notice that you can do. It's a partial payment non-waiver.
Okay.
And essentially you fill that out with the amounts that are due and the payment schedule. And as long as the tenant follows that payment schedule, nothing happens. No eviction moves forward, their lease continues. But if they miss a payment, that document can then be used as the 5-day notice. You send that over to our office. We'll start the eviction process.
And the time is still running through all the payments. It didn't start the whole process over.
Correct.
Okay. What's your advice about drop boxes and stuff? I imagine they just cause too many problems.
Yeah, they really do. Even if you have a provision in your lease that says we're not responsible for the drop box, a lot of the time the judge will say, well, it's your drop box. You are responsible for it. We see people dropping money orders or claiming to have dropped money orders. We never find them. The landlord doesn't have them, or even someone has taken money orders out of the drop box. And then there's a big headache there, especially with money orders because it takes so long for them to be reissued.
Right.
And then the tenant's a month and a half behind before they can get that resolved.
Well, one more thing that I see happen in court sometimes is these residents will come in, and really what they're trying to do is just buy some time. I mean, their next paycheck's coming. They're just trying to buy some time. And they say, oh, Judge, my air conditioning doesn't work, or they haven't upkept the house, and I'm not paying rent until they do that. What's their position on that?
Well, the beauty of evictions is we're in justice court and there's a different judge. You know, every day you could be seeing a different judge. But the law in Arizona is rent strike is illegal. You can't withhold your rent even if your air conditioning or something else is malfunctioning. But that is something that some judges will take and say, well, wait a second, we're going to have a trial on this, and that can really be a headache. So what we need to know as your lawyer, have they given written notice about these issues? Have we ignored them, or have we taken care of it? Because our strongest argument is, look here, Your Honor, we have maintenance requests, but those were fixed. So
right.
They still have to pay the rent. But really, legally, rent strike's against the law, and if they haven't paid, that's the issue that we're there about, and the eviction does still move forward.
And when you're saying rent strike, you're just saying withholding your rent for any reason.
Correct.
Okay, perfect.
Even if you think you're justified,
right?
You know, a lot of different states allow that. They say, hey, you withhold the rent to get the landlord to do what you want, but here that's not allowed.
Chris, what a wonderful podcast, and thank you for all the information of going over something that we really deal with a whole lot. But we do it so much, and it seems so easy as attorneys. But man, our clients can get in a lot of trouble if they really just don't just follow the step by step by step. And if you have any questions at all, the multiple attorneys at Zona Law will be more than happy to take your call. I do know that. Certainly appreciate you being here today and all of your knowledge. And thanks again for coming. And until next time, just continue renting, and we'll do our best to keep you out of trouble.